Greetings, everyone. Donald Trump has until Monday to request a stay in his federal election interference trial. Now, that's a trial that has been on hold until an appeals court decided if Trump had, quote unquote, total immunity while he was president from any crimes he may have done. Well, that court unanimously decided that Donald Trump did not. But Trump can further delay his trial Monday by signaling that he plans to appeal to the Supreme Court. MSNBC legal analyst Mary McCord is back with us. Mary, we will know. Monday is the deadline. Now, if Donald Trump's team doesn't file anything, then Tuesday kicks in and Judge Chutkan can then put that trial back on schedule. What do you think is going to happen here in terms of whether Trump decides to go after the stay so he can appeal? And even if he appeals to the Supreme Court, they may not take it up.
Yeah. So by Monday, and I think it's almost a certainty that he will file a motion to stay. What he's asking to do is stay the mandate. So stay the circuit sending the mandate, which is basically passing the ball back to Judge Chutkan. And he will ask her to the Supreme Court to stay the mandate pending his filing of a petition for certiorari. I don't see why he would file the petition by Monday night because, one, he wasn't directed to. The circuit said all you have to do is file a motion to stay by that time. And two, his lawyers have been pretty busy this past week and they probably haven't gotten it written yet. And three, they want a delay. So why would they file it any earlier? Now, the Supreme Court could grant cert just based on the motion. They did that in Bush v. Gore. Or they could grant the stay and give him a deadline to file his petition, 2 weeks or something like that, something shorter than the normal. Or they could deny the stay. And I do think it's entirely possible they will deny the stay and deny cert even when a petition comes because it was a unanimous ruling. It covered all the bases. And they don't have to agree with every point made by the judges to affirm. If they think that if they think that the ultimate conclusion was correct, even if there are bits and pieces that are not weight-bearing in that opinion that they don't agree with, they don't have to take it just to correct those bits and
Mary,
pieces.
you put your finger, I think, on the salient point in this particular matter that's coming before the court is they don't want to touch this thing. They don't want to go near it, and you have an en banc decision unanimous decision by the lower court, and there's no need for them to open that door here. They can do, and I think you're right. They deny cert, and they go, you know what? Live with it and move on because they've got enough brewing in other areas that they don't want to dance on this one.
Especially in light of what we saw this week, where they treated the 14th Amendment like a hot potato that they didn't want to touch. I almost wonder if you listening to the oral arguments this week, or more importantly, listening to the questions the justices were asking, if it gave you any sense of their appetite to deal with immunity.
Well, I mean, obviously they didn't talk about things like immunity there, but they definitely, they steered very far away from getting into the substance of did Donald Trump engage in insurrection, right? A lot of people thought they'd spend a lot of time on that. Their time was almost all spent on other sort of technical legal issues. Most importantly, why should a state have the power to determine who's going to be on the ballot for a national office, a federal office like the presidency? But that said, it's clear that they're not super comfortable involving themselves in cases, even though it's the duty of the court to say what the law is and to resolve cases when they need to, the cases that have a political implication, particularly during an election year. So the immunity case, just like the 14th Amendment case, clearly has that implication. There's one thing I want to mention when we talk about potential for denial of cert. I mean, that is what they did in the Trump v. Thompson litigation, right? They have shown that they don't really like taking all the Trump cases, when there's a reason not to. And in that litigation, very similarly, this is when Mr. Trump had tried to prevent the archivist from sending presidential records and White House records to the House Select Committee investigating January 6th. He lost at the trial court, Judge Chutkan no less. He lost in the D.C. Circuit, unanimous opinion. He took it up to the Supreme Court, both on a motion to stay, pending cert. They denied the motion to stay. The documents started flowing that very night. They denied cert. And we had Kavanaugh saying, look, these are important issues, but the circuit court opinion applied every possible test from the less restrictive to the most restrictive test. All judges concluded he's not entitled to executive privilege here. we don't need to review this.
I mean,
so that, they've done it before.
Just in case people had not seen the thorough opinion, if you will, from the appeals court, I mean, we could put up on the screen. They write, the judges all together, right? It would be a striking paradox if the president, who alone is vested with the constitutional duty to take care that the laws be faithfully executed, were the sole officer capable of defying those laws with impunity, their decision said. So maybe not. We'll see.
If you're a prosecutor in one of these other cases and you hear Trump's attorney this past week say in front of the Supreme Court, what happened on January 6th was shameful.
Oh, my gosh, it was crazy. Are you going to play the sound? Because this is crazy.
Do we have the sound?
I think we have the sound.
Play the sound and we'll talk about it on the other side.
With Judge Kavanaugh.
And just to be clear, under 2383, you agree that someone could be prosecuted for insurrection by federal prosecutors and, if convicted, could be or shall be disqualified then from office?
Yes, but the only caveat that I would add is that our client is arguing that he has presidential immunity, so we would not concede that he can be prosecuted for what he did on January 6th under 2383.
Understood. Asking a question about the theory of 2383.
Okay, so calling it a riot, calling it shameful, calling it criminal, that is not the party line on what happened on January 6th. So if you were a prosecutor in one of the other cases, how do you then utilize that piece of sound?
Well, I mean, he stuck with the party line that the president. That the former president is immune, right? Is immune. And so that's how he kind of, I think, wiggled out of this, that, yes, we would concede that if there was a successful prosecution under the criminal statute for insurrection, which, by the way, carries its own penalty of never holding office again, that then, the 14th Amendment would apply, but argued that the former president would be immune. I do think, though, that the advocate for Mr. Trump was very like any of other Mr. Trump's lawyers. Usually they're playing to Mr. Trump when they argue, and they fight with the judges oftentimes, and, they're almost belligerent sometimes in court. That was not Mr. Mitchell at all. He was professional. I thought he was actually excellent.
Trump actually got legal representation.
Excellent legal representation.
Those dollars worked.
Imagine that.
Somebody paid for it. I don't know if it was him.
Yeah. Mary McCord, thank you so much for getting up early and being with us.
Pleasure.